Good morning, Mr. Maddox.
Good morning. My name is John Maddox for the defendant, Jorge Vasquez. This is another unobjected to drug certificate case. The majority held that the defendant would have met the harmless error standard, but he was not entitled to it because federal retroactivity law superseded the state law of the clairvoyance exception, and it ruled that he was not entitled to rely on verde to excuse the futility of the objection. It also suggested that the Melendez-Diaz rule was not a new rule of federal constitutional law, and that it wouldn't apply on direct appeal for that reason. Justice Dreeben's dissent, is the position I'm advocating here today, suggested that the defendant did in fact meet the harmless error standard. He did qualify for the clairvoyance exception, and he was entitled and verde excused the lack of an objection due to the futility of it. In regard to the relationship between federal and state retroactivity law, a helpful case.
Let me ask you about the Verdi case again. If there's not an objection, I take it that's an indication that there is not going to be a request for any relief beyond the SJC. It's a waiver of your federal habeas corpus rights with respect to the Sixth Amendment question.
I'm not sure if that's necessarily true. That probably is true, but I mean, verde is part of the rulemaking process here, and at that point, it is the state of the law. At some point, the Supreme Court is going to look at the different positions on this and come out with a rule that everyone has to follow.
But that doesn't answer Justice Spina. I don't think that answers Justice Spina's question.
It's an indication that you're not going to pursue your federal rights, your federal remedies.
You would be deemed to have waived it, correct?
I think you would at that point.
So
yes,
if you waived them for purposes
matter.
of the federal court, why isn't it a waiver for purposes of the state court as well?
Well, I think the federal courts consider determinations of federal constitutional violations in state courts to be primarily questions of state law, and you're suggesting it's a matter of federal law. Danforth versus Minnesota says it's primarily a question of state law. So, for example, if you give a remedy for a federal constitutional violation, and the United States Supreme Court says that remedy is not available as a matter of federal law, your remedy that you gave, even if it was even if you thought it was federal law, is in fact a matter of state law. So if in verde it had gone the other way, that would have been a matter of state law, at least until it went up to the Supreme Court and was decided at that level.
I would think that the reason why you might have different standards applying is that the waiver for purposes of federal habeas corpus relief, I think you would argue, is based on the interpretation of and I'm not going to remember that long name of the federal statute, but it's the statutory law about habeas corpus relief. It's not.
Yes.
It's not a waiver for a constitutional purpose. Right?
Well, I think so, but the language in Danforth, I think, suggests that the approach taken is not that.
That's about retroactivity.
Yes.
Right. That's not about the substantive law, right?
Yes, that's correct. Are we talking about the substantive law at this point?
Well, I thought we were.
Okay.
I thought that was Justice Spina's question.
All right.
What, if anything, Mr. Maddox, do we make of, in this case, or any other case, the fact that some counsel have maintained an objection in the face of what would appear to be settled law? By either the United States Supreme Court or by the Supreme Judicial Court. I mean, what weight, if any, do I give to that?
I don't think you should. I mean, they're speculating as to what the Supreme Court is going to do in the future in the face of binding precedent at the state level. I think defendants are entitled to rely on that binding precedent until it's overturned, and it wasn't overturned in this case until June 25th of 2009. So I think that is the state of the law. And when you're talking about notice,
But if a defendant does not accept that state of the law in Massachusetts and determines that he wants to pursue, if he doesn't agree with the SJC, wasn't a party in the Verity case, he was not a defendant in that case,
right.
but he nevertheless wants to challenge the point.
He affirmatively wants to
Yeah,
change it.
how does he do it?
He can object.
Yeah.
But I don't believe he is necessarily penalized by not challenging the state of the law as it exists. I don't think the other way is true.
So without the objection, has he preserved his right to proceed in federal court?
I think he has, yes.
I take it, for example, and I don't say this is, I'm not taking judicial notice of this, but the consequences of conviction for immigrants, non-citizens, is very severe. It's beyond the punishment that the state imposes for criminal violations. I don't know, but certainly if the defendant is an immigrant, you certainly look to you look to pursuing every possible conceivable option, correct?
Certainly.
It would be interesting to know how many of the cases in which an objection was made because for whatever reason, immigrant status or something else, not because the lawyer thought that they could challenge the law, not because, as Ms. Lee said, because the defendant knew or didn't know that it was cocaine, but because they intended to exhaust every conceivable remedy,
Right.
every conceivable remedy. And so that you may get a level of, I don't know whether you call it over-lawyering, but different lawyering from one defendant to another.
That would be an example of where you would like to pursue an objection for federal purposes, but you can be in state court, and under the federal retroactivity scheme, they anticipate state remedies for federal constitutional violations, and in those instances, you should be entitled to rely on the pronouncements of the state courts on those points of law.
Well, is it your argument? Is it your argument that as a matter of state law here, we have to apply the clairvoyance exception in these circumstances, or that
Yes.
we can?
Oh, it's a matter of you can or cannot. You can simply follow state retroactivity law and jettison the clairvoyance exception altogether. I mean, you have that authority.
Well, if we
But we
follow the state, if we follow the state retroactivity law, where does that leave us here? I know where the federal retroactivity law leaves us. Where does the state retroactivity law leave us?
Well, it's somewhat interrelated because you first of all have to have a new rule of federal constitutional law. Then the clairvoyance exception excuses the lack of the objection. You have a new federal constitutional law here in Melendez-Diaz because it's not dictated by the precedent of Crawford because
That's what you say.
Because the result is not apparent to all reasonable jurists under the Beard test. So you get past the fact that it's a new federal law. The next question is the objection excused? The objection is excused in two ways under state law, under the clairvoyance exception. And everything in this case flows from that business records dictum. That was misleading dictum, and as I suggest in the brief, being misled is not notice for the purpose of the clairvoyance exception. That business records exception affirmatively misled people. It misled this court. You relied on that dictum in your holding in Verde. You weren't wrong, but that's became the law. You were not the only people to be misled in terms of clairvoyance exception or in terms of whether it's a new federal rule. Parties and judges alike were misled by that, including Mr. Vasquez, and it flows from March 8th of 2004 from that misleading dictum. It's underscored by Chief Justice Rehnquist's concurrence in Crawford, where he said, I credit the majority with pointing out that the business records and official records are not testimonial. He was calling Scalia's bluff. He wanted that to go on the record, and Scalia didn't bite. He didn't say, yeah, I'm going to extend Crawford to drug search, ballistics tests, DNA, various items. He didn't say. 5 years later, the other shoe drops. That's Melendez-Diaz. In the meantime, the people are relying on that business records dictum, including Mr. Vasquez. Now, when that dictum became the law of the land in 2005 under Verde, it set it in cement, and defendants were entitled to rely on that.
Now, he
as a matter under the clairvoyance exception.
Vasquez's trial took place before the petition for cert in Melendez-Diaz?
Yes, Your Honor.
Okay.
The objection is excused. You said there are two circumstances. One, the clairvoyance exception, and just remind me what the other one is.
The other one is just you're entitled to rely on state law as it exists, and if an objection would be futile, you're not obligated to make that objection. That's something that Justice Dreeben said in her dissent, and it's a separate state law basis. So even if you decided to do away with a clairvoyance exception in this case, you'd still have a separate state law basis for excusing the objection. And in Danforth, the U.S. Supreme Court anticipates that state courts will provide remedies that go beyond federal minimums.
Sure.
Mm-hmm. Now, if we were to use clairvoyance, I gather the clairvoyant period would end upon the taking of cert in Melendez-Diaz.
I didn't actually. I think I may have said that in my brief. If I did, that's not. I don't think that now. I've read the amicus briefs on that point. I'm sorry.
If you did, the rest of the defense bar that didn't object after the petition for cert have let you know that that's not. Don't concede. It's not in your case.
Amicus has filed a brief saying that it should be the date of the decision.
The correct date, I think, is June 25th.
We're not going to hold you to that.
But if you take futility, I gather, regardless of what you may feel about clairvoyance, the time is not the taking of cert. The time is a decision in Melendez-Diaz.
Yes, Your Honor. It's good law. It's good law until it's overruled on June 25th. And also, just in terms of clairvoyance, I don't think the cert is the right answer either, because it's making the defendant speculate at his peril as to whether or not the U.S. Supreme Court is going to take up the issue in the future. And that's
well, it's not as his peril. I mean, all he has to do is object.
Well, I suppose, but I think he gets to rely on the law of the land.
Yeah, but
he's not losing anything by
I take it in.
He's not losing anything.
I take it in part. Ms. Lee answered that by saying, he wants to object to my certificate. I'll tell you what I'm going to do. I'm going to bring my scientist in who's going to tell the jury just how pure this is, right? So it may be at his peril. Right?
Yes, Your Honor.
Maybe. I mean, I don't know. But that's exactly what I assume that's what the prosecutor would do. If there's an objection to the certificate, get the there are not going to be that many objections to the certificate pre-Melendez-Diaz.
Certainly.
The objection would just be overruled, so
Right.
why would the prosecutor do anything?
I mean, while Verde is law, the prosecutor's not
Well,
going to do that.
because if the defendant gets up and says, "Excuse me, Your Honor, I'm trying to preserve my federal habeas corpus thing, and I want to object," and
If I may, I'd like to touch on the facts of this
Yes.
particular case. The Commonwealth's best evidence was that there was an exchange where there was an item exchanged for $120, and there was references to the item being crack cocaine, an 8-ball.
Could I ask you a question about the first one? When the officer asked, I want an 8-ball, and either the defendant or somebody left and brought back something and handed it to the officer, did the defendant himself, I haven't looked at the trial record yet, did the defendant himself say, utter any words that identified what he was handing over as an 8-ball?
I think it's unclear as to the first transaction. In the second transaction, according...
That sell to him or sell the crack?
In the second
depending
one,
on
he said he didn't have 16ths. He had 16ths. He didn't have 8 balls, and he called down to his friend Munchie, and Munchie sold him the 8-ball, according to Trooper Rivera. So if you can convict him on that, you still, nevertheless, the drug certificates would have contributed to the verdict under the harmless error standard. Under substantial risk, the circumstantial evidence is very meager. There's only 30 pages of direct testimony by Trooper Rivera. It's a very short record. He's describing 2 undercover transactions. He doesn't describe, he describes his training, but he doesn't describe any training that involves drug identification or recognition. He was not qualified as an expert for giving an opinion, and I guess I better leave it there. At any rate, I think the circumstantial evidence is exceedingly meager also. Thank you, Your Honor.
Good morning, Ms. McMahon.
May it please the Court, Catherine McMahon for the Commonwealth. This is a post-Verde, pre-cert Melendez-Diaz case. In this case, when it was jury waived, when the trial prosecutor offered the certificates of analysis into evidence, the judge asked defense counsel whether he had an objection, and he said he did not. On appeal, the defendant, and before the appeals court claimed the clairvoyance exception, a majority of the appeals court rejected it, applied the substantial risk of a miscarriage of justice test, and affirmed the defendant's conviction. The appeals court did say, though, that if the clairvoyance exception applied, and if it had to apply the harmless error test, then it would have reversed the defendant's conviction. So this is one of those cases where the standard of review clearly may mean something significant. The Commonwealth's position is that Melendez-Diaz is simply an application of Crawford. It is not a new rule, and therefore the clairvoyance exception doesn't apply. I cited Agapito Leo in the Commonwealth's brief. I understand in Leo there had been no Gonzalez case, there had been no Davis versus Washington case, but in that case the court found the defense attorney at trial on appeal had been ineffective in not raising the Crawford issue because there was a genuine opportunity because of the discussion in Crawford about that core class of statements that might be testimonial. That was with very little guidance from the Crawford court, simply laying out several things, including affidavits, including statements that people make that might be used by the prosecution. And in Agapito Leo, this court found that defense counsel should have raised the Crawford issue on appeal and therefore was ineffective and granted the defendant a new trial.
What was the nature of the hearsay in Leo?
And it was pre-Gonzalez and pre-Davis, but it had to do with spontaneous utterances, that situation. So one, it's not the same type of hearsay as here. Here we have certificates of analysis. And two, there was no case by the SJC interpreting Crawford on that point, but this court found a defense attorney ineffective in not raising a Crawford issue when all there had been was the Crawford decision. In Verity, this court relied on Slavsky and Harvard old Massachusetts cases, but in two footnotes pointed out that some jurisdictions went along with how this court decided Verity that it wasn't testimonial, but noted that two others had found that it was testimonial. After Verity and before this defendant was tried, other jurisdictions had deemed these kind of drug certificates to be testimonial. So in the country at the time that this defendant was on trial, even though Verity had been decided, and even though cert had not yet been granted on a drug certificate case by the U.S. Supreme Court, it was percolating throughout the United States that there was a difference of opinion as to whether these were testimonial or not.
Ms. McMahon, let me ask you this question. Do you know of any case where the Chief Justice of the United States Supreme Court has said, albeit in a concurring opinion, this rule that we are announcing today does not cover X, right? And 5 years later, a majority of the Supreme Court says this rule does cover X.
It applies to X when X is prepared for purposes of court, putting it into
No, wait, I haven't finished, so you have that. And where subsequently, where the issue in the United States Supreme Court, nowhere else, is the later decision, in this case Melendez-Diaz, a new rule or not?
Well, the U.S. Supreme Court said that Melendez-Diaz was a straightforward application of Crawford.
One might say that's Monday morning quarterbacking.
But it's not the quarterback, it's the referees who said it.
So,
Unfortunately, there's a last word on,
so, some state courts may think that, of course, it's the referee calling, I think it's the balls and strikes, isn't it?
Robert says.
But other courts may be interested in how the game is played, beyond just the calling. And so we say, as a matter of state law, can we? We're going to treat this as a new rule?
no, because it's an interpretation of the Sixth Amendment, and the last word on that is the U.S. Supreme Court, where the U.S. Supreme Court, even looking in Melendez-Diaz, said that they were not, the majority said they weren't overturning 90 years of precedent, that Massachusetts and I think 2 other states had viewed certificates of analysis historically as not testimonial, but other jurisdictions had not. So when the U.S. Supreme Court is looking at 90-odd years of jurisprudence, it's looking at 90-odd years of jurisprudence of the Sixth Amendment in the federal courts and the state courts throughout the country. It's not looking at like one little individual court in one individual state. And that's going into what Ms. Lee said. We're talking about the U.S. Supreme Court is the court with the final say about what the Sixth Amendment means and how it applies.
The question is, under Danforth, couldn't we say, of course we accept that this is what the Sixth Amendment means, but as a matter of state law, we're going to interpret it as, or we're going to, because we consider it a new rule, we're going to let our defendants in our state whose cases were still pending on appeal take advantage of it.
I didn't read Danforth to mean that this court could say that something that the U.S. Supreme Court said wasn't a new rule was a new rule. I interpret it to mean that when it was a new rule, that the U.S. Supreme Court was not going to extend collateral back to cases on collateral attack, that kind of retroactivity, that a state court could say, oh, your case was tried and your appeal was resolved before Crawford came down. That was a new rule, and we are going to allow you to raise that in a motion for new trial. Or we are not going to, but it's a matter of a state decision, not an interpretation of whether it's a new rule or not, but how far to apply the new rule.
So
that's how I read it, and
I understood your careful answer to Justice Watson, that that's not how you rule Danforth. Are you saying that we cannot do that, given what the United States Supreme Court said in Melendez-Diaz?
I think since the way I read Melendez-Diaz, saying it's a straightforward application of Crawford, that Melendez-Diaz is not a new rule.
And that applies to whichever court in these United States of America and its territories, it isn't a new rule.
That's my interpretation. And my understanding of Bochting and Danforth, we're dealing with how far to apply something that is a new rule. And if the U.S. Supreme Court says we've created a new rule, we're not extending it back this far, a state could say we are extending that new rule
But
back.
I understand the difference.
But I don't read it to mean that a state could say, oh, no, you said it's not a new rule. We disagree. We think it is. I don't think that that's...
So you're suggesting federal law prohibits us from treating this the way defense counsel would like us to treat it?
I think to say that Melendez-Diaz is a new rule is ignoring the holding in Melendez-Diaz saying that it wasn't a new rule.
Can we say that objecting during this period of time would have been futile under our sort of state rules with respect to
It may have been futile for having the certificate kept out of evidence at a particular trial, but it wouldn't be futile in terms of preserving a Sixth Amendment claim of error.
But if we say it would have been futile in terms of keeping it out of a state court trial, can we then apply essentially the futility exception and consider these as if they were raised, these objections? Can we do that as a matter of state law is what I'm asking. This is a federal law. This is a decision of the United States Supreme Court interpreting the federal Constitution. So the Supreme Court has said that it is not a new rule. If you want to preserve your federal claim of error, you have to object, even if
the particular trial judge, and we all know, we have the records where some defendants have objected and the trial judges have overruled the objections, sometimes saying your rights are saved, sometimes just overruled. But that's just one step. The next question is, upon conviction, what standard of view do you get here, and can you go further under habeas?
So it's your view that if we were to say that we will forgive the failure to object and we will consider it, that the U.S. Supreme Court could say that we are in violation of what for doing that? What constitutional provision have we violated by doing that?
No, if you're going to say that Melendez-Diaz is a new rule,
Well, I'm not sure what we're
No,
going to
no,
say.
no.
but
All right.
Let's say we don't use
Let's
those
assume that we
magic
forgive.
words.
We forgive the failure to object, and we're going to review it as if they objected. Whatever the rationale. Who knows what we're going to do? But let's assume for this question that
as
that's
a-
what happened.
a
Are you
matter
saying
of-
that would be unconstitutional?
I think in terms of like preserving or waiving, I think the substantial risk test, the way it's been worded in some cases, is that it's a discretionary standard. In some of the older cases, like it's waived, period. It's waived, well, therefore we will look at it under substantial risk. That in terms of viewing it as waived or not, that I think may be a matter of state appellate procedure. Saying Melendez-Diaz is a new rule, I think would be contradicting the U.S. Supreme Court, which I think the court can't do. Procedurally, treating something as waived or not and giving people the benefit of verity, I think, is a matter of state appellate procedure, for lack of a better way of articulating it.
All right. So if we have the discretion, whether we should exercise it or not, let's put aside new rules, old rules. In terms of basic fairness, why should a defendant who had an attorney wise enough to object be treated differently from an attorney who was less, from a defendant whose attorney was less wise and didn't see what was coming?
That's for every kind of error in any kind of case. Some attorneys object, some attorneys don't, and you apply whatever standard of review based on whether it was preserved or not. Here, because of how it was percolating throughout the country, how even in Verdi there's a discussion, albeit in a footnote or two, about how there's a split in the jurisdictions, and how by the time of this trial there were several jurisdictions that were in disagreement with Verdi, that here it's not necessarily a wise person who preserved the error.
And then does each of the defendants who you say would be in that situation then has a collateral attack as an ineffective assistance, and we would need to allow it?
Not necessarily, because then you look at that stage, it's an omission by the defense, so a substantial risk of a miscarriage of justice kind of a thing, and you apply the factors to see whether or not it prejudiced the defendant. But it would be a waiver standard applied at that level. And that would be when you would look into the facts of the case. And I don't know if you want me to turn to the facts.
Yeah, what about the evidence in the case? How?
Okay, in this case, it was an undercover trooper, part of a drug task force working in Springfield. He had 9 years of experience. He had training. He didn't go into the specifics of his training. He had made hundreds of arrests in Springfield. He testified that in July, on one occasion, he had gone up to the 4th floor. It was, he had been stopped by people as he proceeded up to the 4th floor. He got into looking for somebody named Flacco. He was introduced to the defendant. It was a barricaded apartment. There were 2x4s on both the back or front doors, because when he exited after the sale, he went out the barricaded front door and he saw that there was somebody there, ostensibly a lookout. He asked the defendant for an 8-ball. The defendant had somebody produce something for him, and he paid $120.
Did the defendant say anything to him when that?
They spoke in Spanish. He didn't say what he didn't say what the defendant described it as in that circumstance.
Ms. McMahon, maybe I can just, because your time is almost out. Do you disagree with the appeals court that if we apply the substantial risk standard, there was no substantial risk, but if we apply the harmless beyond a reasonable doubt standard, you cannot say that this was harmless?
I want to say two things about why it's a closed case, but why it might not be harmless, because I understand that that piece of paper is there for the fact finder. And so.
And
but
why
I
it might
think
be harmless.
In this case, you have the police officer when he's being cross-examined about, there were two pieces of drugs in one envelope. And he said that the item number 2 was the item that he had purchased. It was crack cocaine, and based on his training and experience, it was consistent with crack cocaine. You have that. You have on the second occasion the trooper asking for an 8-ball, the defendant having 16s, the defendant calling down to Munchie to get an 8-ball. So in that time, you have the defendant using the words. Then you have, when there's the execution of the search warrant in the department, it's still barricaded. The defendant has over $400 on him. Someone else is flushing money down the toilet. There's a scale, there's scissors, there's baggies on a kitchen counter, and there's a small amount of cocaine in a bag above the kitchen counter. In those circumstances where it looks like it's a barricaded drug dealing den with the defendant's exchange of, you ask for an 8-ball, and him calling out for an 8-ball, and the delivery of an 8-ball, and this trooper saying that the first 8-ball was consistent based on his training and experience.
Can I ask you this question?
That it might be enough.
Can I ask you this question? Let's assume that for whatever reason the Commonwealth does not rely on drug certificates, right? And relies on police testimony. And the defendant tests the drugs, and it turns out that the drugs are not cocaine. What happens?
Assuming that there wasn't a not guilty.
Well, I think you just answered my question.
Assuming it wasn't a not guilty.
I think it might be a not guilty. Thank you, Ms. McMahon.
Thank you.
If you want, yes.